with your Lordship's kind request, Lord, we discussed among ourselves. It will be difficult for all of us to finish by 2, Lord. Because the 9 judgment, it's not going to have far-reaching consequences.
See, we have to conclude the matter by lunch tomorrow. Because all of us have regular benches after lunch tomorrow.
Yes.
And we have the call of conscience towards other litigants who are waiting for years.
Yes.
So we have to get back to our regular benches tomorrow afternoon. And 3 o'clock today, he'll get 1 hour today, and he will get 2.5 hours tomorrow morning. So 3.5. Between you divide it.
We'll
so that
divide ourselves.
Give us a small note by the morning tomorrow. Just 2 pages, Mr. Dwivedi, because we've made very detailed notes. But just what the punch points which you are going to make in response to what they have argued.
That's very kind of you.
Lord, we'll also we'll give our punch points. After
I think so. If you,
We'll do that.
we'll give you until 3 o'clock, and then you can.
So let's start.
Great.
I'm deeply obliged.
We completed before the time.
So these are the matters to be detagged. The nodal council have given us the 2 matters to be detagged.
Lord,
The
what,
nodal council have given it. I presume that everybody.
Lord, what I would request is, Lord, that they may not be detagged because some of the issues are common, like royalty, what is
Lord, are the
royalty.
Assam matters?
So, Your Lordship,
All right. We'll not
submissions
pass
will
any-
be limited.
We'll not detag it right now.
At the end of the
At the
day-
end, when the judgment comes,
Then they will go before the appropriate bench for
Appropriate
the.
bench.
Yes.
Or Lord,
May I request, my lord, so far as 2 matters are concerned, my lord, ONGC and oil. Lord, if your lordships can consider recording that in view of the affidavit of MOPNG, since they have a separate regime, the matter is detailed. Whether now or at the end of the judgment.
we are fair enough, no difficulty. Who's for the? So long as both the learned council are agreed in this course of action, we can do it. There's
No,
no
because
difficulty.
I'm appearing for state of Assam.
Lord, I pray for Oil India. Mr. I'll agree with the solicitor, Lord. There's only one
And
issue is
Mr. Dwivedi is appearing in that very matter.
Yes, Lord, it's for state of Assam. Lord, what is royalty will be common there.
that's
Lord.
common.
And
Lord, let it be
49 will
tomorrow,
be
my lord,
common,
possibly.
so-
Yes.
Possibly,
So
Mr.
what we
Dwivedi will agree, my lord. Kindly.
between 2 or 3 seniors, if you could look at all the matters on our board,
Yes.
right? Eventually, these matters will be sent to a regular bench. But whatever matters are to be completely detagged. If you can just make a little list, if you sit for 15 minutes between all of you over a cup of
Yes,
coffee,
we'll
you
do
can be
that.
able to
So
give-
that will go separately after the
But
judgment.
as
After
far
the
as
judgment.
ONGC, Oil
I-
India,
I-
right,
I-
they will be
I-
detagged. No, what solicitor is right. They are in a different regime. The only thing he was mentioning.
Mr. Dwivedi, what is
No, Lord,
royalty? Anyway, we are hearing
say
you.
something.
Whether we detag it or not, we are not going to deny
No,
permission.
so
only
the
on-
state will be there. I will not be adding anything new on that. Lord.
All right.
Whatever I'll say will be equally applicable.
Anyway, my lord, may I say,
those matters.
Lord, the only additional point in
Lord, may I,
Yes,
Mr. Datta, if you don't mind, Mr.
Yeah.
Datta, if you don't mind, but possibly I'll be able to persuade Mr. Dwivedi by tomorrow. I'll mention tomorrow.
all right, all right,
The state of Assam may be agreeable.
all right.
It will require something.
very
more
loaded
to
comment.
consider.
Very loaded comment.
No, 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 I
He's
request.
going to make him an
I
offer he
persuade
can't
Mr.
refuse.
Lord,
Now, let's-
the only interesting point there, which solicitor will point out, Assam fresh levy tax on the entry 14 and list 2 on the oil field.
We are not arguing that, Mr. Datta.
No, I'm not arguing. I'm just mentioning
For
that.
a private party there, don't do this.
All right, let Dr. Singhvi begin then.
Now, it's 10:45. I am going to crave your lordship's indulgence to read from the note the extract. Otherwise, it will take too much time to go. I'm going to race along.
Certainly.
Lordship will allow me some speed reading
Certainly.
with apologies
Where
to
is the
lordship.
note, Dr. Singhvi?
Yes. 305 it starts, but it is not in the. I will take your lordships back and forth. So your lordship follow my para numbers. I'll tell your lordships. Volume 2E.
E.
2E 305. And well, there'll be no repetition. Most of the points are new, and I'll race along with your lordship permission. I'm going to keep to the time, Willis, to the maximum extent possible. Is where it starts.
Dr. Singhvi, just give me 1 second. That's all. I complete.
The new page. 305, as I started yesterday, has my 6 propositions, seriatim. And my lords had heard me briefly on each of those 6 yesterday.
Yeah.
There is one point I must point out. The paras I have given against each proposition, which are valid.
Right.
But the pages have been changed by the person who manages it.
Yes.
So my internal pages have been taken away. You should be having the new pages, I think. Right. Now, the first point I wish to take your lordships to is royalty is a tax. And I've broken it up because I'll be reading less than half of these paras, but lordship will allow me to go in my sequence in that. Because what are the elements of my first proposition? Royalty is a tax. The elements are: number 1, your lordships cannot ignore and must not ignore 366(28). It's a constitutional provision. For ease, it is quoted at my B3 at 325. That's the way I want to proceed. It will be much faster. My B3 at page 325. The elements are that your lordship has an inclusive, which means an expensive definition of tax. In a sense, tax proper and akin to taxes or deemed to be taxes, which are imposts. The characteristics are given in my B3, page 325. Tax or impost, general, local or special. So it's an inclusive, expansive approach. Now, it is so understood, going back in my para B1, in not merely general cases, but in extremely important general cases. Para B1 is at page 325. I've given a list of your lordship starting from Shirur Mat, 7 judges. All of them reiterate the famous dictum of a tax by Chief Justice Latham, which is my first para. All of them. I ask myself, which is the element of this missing? None. Is it compulsory? Answer, yes. Is it public authority? And most important, enforceable by law. I know a lordship has 2 queries. One is royalty is not a tax, it's a share or a consideration. Second is it's charged by private persons. Please leave it for 2 minutes. I'll deal with both of them.
So what are the ingredients for compulsory?
Just see B1. B1. Your lordship need not note. B1 has them. Underlined, highlighted. 3 to 5. That's why I said it will be faster this way. This Chikri is cited by your lordships in 7 judges, 5 judges, and 9 judges. Shirur Mat was 9 judges. Jindal is 9 judges, Shirur Mat was 7 judges. Next para cites them. Shirur Mat is 7, Jindal is 9. So, all the elements are satisfied. Now, the case which alone I want to read, I'm skipping, is McDowell in B5, which is 326. And even in the cases, I'll read only the highlighted portions. B5, 326. May I read the second half, para 22, if your lordship has got at page 326, quotation of McDowell, all my lords have it.
Yes.
Under 366(20), but this is a constitutional article, how can it be ignored? 366(28). Taxation has been defined to include the imposition of any tax or impost, whether general or local. Impost means compulsory levy, non-volitional, not optional. The well-known and well-settled characteristics of tax in its wider sense includes all imposts. Impost means 1, incident of sovereignty. 2, law means an act of legislature. We know 265 very well, Malas. The term tax under 265 includes imposts of every kind, tax, duty, cess or fees. And the idea of 360(28) is to be expansive and inclusive, not restrictive.
Dr. Finji, the problem with your argument is very simple.
Private and...
If your argument is right,
yes,
that would mean that wherever a contract is a statutory contract,
yes,
that it is a contract within the fold of a statute, not just regulated by a contract, but there are statutory contracts. Then any payment which is made under a statutory contract becomes in the nature of a tax. We'll have to go as far as
no, you should not have to. Give me a...
Comes down to that.
No, it will not have to. I assure my lords. Your lordship will have 2 considerations which fell in the open argument which I was hearing earlier. 1, if it's a tax, how do private people collect royalty? That was one argument against which I'm answering in a minute. The second is royalty is not a tax, it's a share or a consideration. The judgment from the Saurashtra, Gujarat. These 2 I'll answer in a minute. Your lordship will be satisfied. I've dealt with it. But first, I'm on the elements of a taxation, which McDowell...
The licensee which is paid
Yes.
for the state to partake, or for the state to part with the privilege of selling alcohol or liquor, it becomes a tax. It's not a license fee by this.
Well, if it's a
The
statutory
state,
contract,
it's
contractual-
because the state parts with the privilege to deal in liquor,
Yes.
right?
Yes.
You pay a royalty, you pay a
I'm
license
going to
fee.
say it's a tax.
It's a tax.
No,
By
I'm
this.
not saying it's a tax. Whereas if your lordship has, see, contracts, whereas ultimately under the law are contracts, whether they are under the fold of a statute or otherwise. So there will be whereas consenting parties with a contract to which I cannot argue then that that's a tax. I'm going to say it's a contractual fee. There is no contradiction in my argument, whereas it will remain a contractual, consensual payment. Somebody will pay 10, somebody will pay 20, longer term, lesser term. It is contractual, it is not tax. The real only two questions against me on this section are the private person collecting royalty, which I'll demonstrate in a minute why it's a wrong argument, and one of the Saurashtra High Court judgment. I'll deal with them in a minute. So, first, your lordship has got B5 at page 326.
Yes.
Clearly, the characteristics of a tax are satisfied, absent those two contra points which I'm coming to. Now, Malus, on this, my conclusions, if your lordship doesn't mind, are at B13 at 328. This conclusion, so lordship, see, I'm skipping large portions with your lordship's permission. Then I'll deal with those two contras in a minute. May I read B13 at 328? My lords have got it. Royalty and dead rent is a compulsory impost under a statute and not a result of negotiations leading to a contractual agreement. It is unilateral. The mining lessee has no say in its determination. The rate of royalty is fixed by the Parliament in the second schedule. Now, this is a very important characteristic of a non-contractual impost. Your lordship fixes it in the schedule. No options, no discussions, no consent, no negotiation. And can be varied or amended by the central government subject to limitations imposed by 9(3) by a mere amendment. The rate of dead rent, which is actually a more important example, not been given sufficient weight in 9A, is also fixed by the third schedule and can be varied or amended. The recovery is capable of being enforced by coercive means. Your lordships, in that very relic of the past, that contractual exaction of royalty by a private contractor, does not have 25 enforceability. Then, Malus, hence it is submitted that royalty meets all the requirements of at least an impost. Then, Malus, your lordship will come to, may I just straight away take a lordship to the two contras, which I myself formulated against myself. One is at Malus 328, para 15 onwards. This I have dealt with, Malus, the Gujarat High Court judgment. Incorrect to characterize royalty as consideration. May I read through very quickly, Malus? It will be faster and easier if I read these paras.
Yes, very well.
Royalty imposed under 9(1) ought not to be conflated with the concept of royalty as consideration share of income, such as intellectual property, music, artworks. Such royalty would be determined through negotiations between contracting parties. Royalty in its very essence is based on removal, consumption. There are 9 judges. Your lordship has to lay down the concept one way or the other very clearly. This will endure for a long period of time. And Malus is very interesting. Let me digress for 5 seconds, Malus. 4 months after India Cements, which held it to be a tax. 4 months. Learned judge who was a member of the India, who was heading the bench of India Cements, Chief Justice Venkatramaya as he then was, holds it as 4 months later that we held so that it's a tax. They did not misunderstand their own judgment, Malus. It's only Malus the interpretation of Kesoram that you are misunderstanding your own judgment. Now, Malus, kindly see. Royalty in its very essence is based on removal or consumption of minerals. Although the terms removal and consumption are not defined, they are linked closely to the terms production and dispatch. These are directly linked terms. Your lordship has them defined 3A, 3FA. I'll not read them. Removal, consumption, products, derivative meaning of production or dispatch. I'm not reading it for saving time. Now, C customs is a general point. It's not on this. It holds that it is akin to excise. It's 7 judges. 9 judges. C customs is 9 judges. And just see the bold face on the next page, 330. My lord is saying, seeing I'm jumping, I'm only going to the highlighted portion. Lord will pardon me. I don't have time to read all. Excise duty is primarily a duty on the production. What is removal? What is dispatch? What is production? What is it, Malus? You don't call it excise, but it is in the nature of a duty. Excise is primarily a duty on the production or manufacture of goods produced or manufactured in the country. Next para. Therefore, both excise and sales tax, of course, are different taxable events, are levied with reference to goods. The two are very different imposts. In one case, the imposition on manufacture or production, other is an act of sale. Now, I'm not saying this is a case on mining. It's a general case. It is, now come to Hingir Rampur and the nature of royalty is more akin to that of an excise duty. Hingir, and if in Hingir, your lordship will just come to 331, the page number, fourth line. This raises a question as to what are taxes on mineral rights. Obviously, taxes on mineral rights must be different from taxes on goods produced. If taxes on mineral rights also include taxes on minerals produced, there would be no difference between taxes on mineral rights and duties of excise under 84. A comparison of list 1 and 2 shows that the same tax is not put in both the lists. And whereas 50 is a unique entry, it uses the word tax on mineral rights. They don't use the word mineral development, they don't pick up the word for anywhere else. Therefore, taxes on mineral rights must be different from duties of excise, which are taxes on minerals produced. The difference can be understood. I'll skip those lines, lordship permission, come 4 lines below. There should therefore be no difficulty in holding that taxes on mineral rights are taxes on the right to extract minerals and not taxes on the minerals actually extracted. This is actually my proposition 4. It's coming later, but the judgment is the same. Thus, tax on mineral rights would be confined, for example, to taxes on leases of mineral rights and a premium of royalty. Taxes on such premium and royalty would be taxes on mineral rights, while taxes on the minerals actually extracted would be duties of excise. And then the last 4 lines underlined, not boldface, last 4 lines, same page. Therefore, the present cess is not a tax on mineral rights. It is a tax on the minerals actually produced and can be no different in pith and substance from the tax produced. Now, Saurashtra, I know, has been cited against us, B19. I'll skip that because it is approved by Keshuram. I'm skipping that. That is cited in B19. Come to B20. What is the reason in Saurashtra? With the deepest humility, the reason is, if you don't want to have this tax, don't go mining. Well, that's the reason given. Now read my para B20. Every indirect tax, in that sense is optional. If I don't go and buy a good, I won't have to pay the tax. So that means I should not buy the good. However, the underlying logic of this reasoning, this reasoning is the Saurashtra reasoning, Gujarat High Court. It is respectfully submitted, and that's adopted by Keshuram. That's the problem. Gujarat by itself would not have been a problem. It's adopted by Keshuram. It is respectfully submitted, patently erroneous, in as much as the choice of whether or not to undertake mining operations by obtaining a mining lease cannot possibly take away the character of royalty as a tax, for the reason that this choice is available with respect to all indirect taxes. One may or may not buy goods or may or may not avail services. That cannot possibly make the indirect tax that would otherwise follow something other than a tax. Now, who are the people operating this system? See the next paragraph. From time immemorial, apart from India Cements, apart from 9 judges, this is the Indian Bureau of Mines, which is the mother organization for all this. Royalty in the strict sense and common parlance may not be a tax. It can be viewed as a kind of tax, which is why 366(28). Linked either directly or indirectly to the intrinsic economic value of a mineral realized through sale by the lessee. Royalty of mines cannot be a fee, but a levy in the nature of the tax. Then next page, 333. Royalty on coal is a tax. Then, I move to B23. International Monetary Fund, not that it's at all in any way binding. It's a working paper. I've quoted that. Don't read it. It's saving time, I've quoted it there. Please look at it. Come to B24, which is on general interpretation, your lordships can use an external aid, because some of these are external aids to interpretation. And now, just note on the side of B25, a conceptual point, which is not put like that. Your lordship has taxes which are royalty under 9. This lordship I have not put here. Lordship I want to note on the side of B25. Royalty is a tax under 9. Dead rent is a tax under 9A. DMF is under 9B. Only thing which I get a quid pro quo and a benefit is the 4th one, NMET, the exploration tax. That is 9C. That can go in the category of fee, but it's an impost covered under 366. It's the 5th one, which came in 2015 in my B25 para, which is a bidding parameter. That is contractual. That is not a tax. This what happens is, Malas, after the auction regime of 2015, I have to bid. So I bid 10 rupees, he bids 20 rupees. On that bid of mine, depending on the bid, I have to give a share. That's my contractual thing. That's the fifth one which has come only in 2015, which I've quoted in B25. All the other are compulsory exactions. I'm only contrasting it. It's called a premium, but it's actually a contractual exaction, a contractual payment. And that is the closest to a share or a consideration. I'm contrasting it, Malas. And your Lordship, Malas, has got the B25 and B26 on that. Now, Malas, I come to the other contrapoint. If it is a tax, Mr. Singhvi, how do private persons collect it? Very simple answer, Malas. Let me give the answer first and I'll read the rule. Malas, it is true that it is a relic of the constitutional past. But Malas, the tail should not be allowed to wag the dog, as was mentioned yesterday. This will be a case of tail wagging the dog. It is a very, very few number of states, and my learned friend relies on Theresima, Mr. Devedi cited it, which was Kerala, which had forgotten, I would use the word forgotten, to pass a law saying that the mineral under the earth is the states. Incidentally, after Theresima, Kerala immediately passed that law. Most other states, 99% have that law. It is true that there may be one or two examples, which I call a tail, Malas. That will not decide a 9 judges approach. That royalty is not a tax because 0.1% cases may be there in the country where the mineral does not vest in the government and therefore there can be a private lease for which royalty is paid. That's answer number one. Answer number two is very interesting, Malas. Is that even in those private lease cases, the 2016 rules make it clear that it is completely controlled by the government. Because the private man, he's the private lease owner, he can't give me a lease. He has to go through a gamut of prior authorization by the government under 2016 rules, which I'll show in a minute. And the third reason is most important. This private leaseholder cannot enforce through 25. That's the hallmark of a sovereignty of a tax. So, Malas,
What is the third reason?
Third is this private fellow who has a relic, Malas, a few occasional leases here and there in the country which have not been taken over by the government, cannot use 25 to enforce. Enforceability is given only to the Malas exaction. Section 25 is clear. Now just read the paras in that light. 3 points I have given, Lordship, all three are covered here.
Sovereign function.
So B27
That is with regard
of
to
my page, Malas, 334. .334 is the Theresima Kerala case
Yes.
at B27. At 335 page number of my written submissions, I have said in the first 3 lines, there was an absence at that time of a provision in the Kerala land revenue declaring the ownership of minerals underneath to vest with the state. That is one of those anachronisms. There is hardly a place, 99% would not be that. It's a relic of the pre-constitution position, which I have said. I don't want to read it, Malas. Second B28 is the section 25 point, which I just made. B28A, section 25 and 21 bracket 5, the recovery provisions would not be available to private lessors, thereby changing the very character of royalty. The grant of mining lease concessions by private person is not unqualified. Now see this authorization in rules 27. Where is that? This book you should have to take 2000. Actually, although the private man has the lease, he can't sneeze without permission from the government. All of it is regulated.
All right.
Well, rule 27 is not given here in this bunch, but your Lordship has that book.
Yes.
It's got a 2016 rules, which says for a private owner of a lease to even Malas negotiate with him and give it to him, everything is covered by prior permission and authorization. He can't. And this is true of Malas minerals other than hydrocarbons and atomic. In hydrocarbon and atomic, of course, there's no question. It is already gone with the state. But for all other minerals, every other mineral. So Malas, it is a relic. It's an argument used to decide the main matter where 99% leases are not there and Lordship is, It is true, factually. I can't deny it. But it just doesn't make sense to interpret it on that basis, my humble submission. Now, that's the 2 points. And lastly, Malas, as I finish my first proposition, just see that 4 month later judgment by the same learned judge who presided over India Cements and how he understood tax. Kindly see the Honorable Chief Justice in volume 5I, page 67. Starts at 65, at 67. He presided over India Cement. The learned judge who presided over India Cement, 4 months later in a former bench. Oh, come on, give it now, give it.
Just that.
5I? Yeah, 5I starts at 65, relevant at 67, para 6. And I will always hearken back to that question. What is so specially wrong about India Cements? Or what is so specially correct about Kesharam?
Which part is that?
Para 6 at page 67. That this entire established law should be changed.
Months after the.
I'm sorry, not 4 months, 2 months after India Cements. 2 months after India Cements. Well, the Chief Justice, as he then was, says, we do not find much substance in this contention. Does my Lord have para 6?
Yes.
Recently, a constitution bench of this court has held in India Cement. Recently is 2 months earlier. That the royalty levied on the extracted mineral was the nature of a tax and not in nature of a fee, which could be used only for specific purpose. Any tax realized, etc., consolidated fund of India. I'm not reading, but it's save time. Well, all this is happening because of 5-judge bench, at least judicially, Malas, has set the cat amongst the pigeons. Unless there's some overwhelming reason why a lordship should not follow a 5-judge bench. Malas. Otherwise, the law was very clear, understood as clear. Malas, coming to my second proposition, I must race along, Malas. Dead rent is the second proposition. At page 335, it starts. Is clearly even a fortiori a tax. As your lordship knows, the scheme is central government occupies in 9 the royalty. In 9A, it starts occupying the dead rent. But I would like to call a dead rent an idling charge.
Is made to the government. Will a minimum guarantee payment also be partake the character of a tax? Because in a large number of situations,
Yes.
a minimum guarantee payment is assured to the government, whether it's an electricity company. Because the principle is you must lift electricity.
No. Answer is very simple. I appreciate my lord's question. It's very important. Nobody can say a minimum guarantee.
Suppose there's a public-private partnership. Government wants an assurance of a minimum revenue. It says you must give me this, irrespective of what profits you make.
Straight away. There's no problem. Every example which your lordship has in mind will be contractual. Every example. What are these public PPPs, Malas? One is a BOT highway. Second is a tender. Third is an auction. All contractual. This is, Malas, an exaction under 9A. Your lordship has a clear dividing line, and I'm not going to be inconsistent, Malas. I've just yet to show your lordship a very interesting statement of objects and reasons when 9A was brought in. Your lordship will be shocked. Every case will fall in the contractual versus the non-contractual exaction line. And that's why 366/28 is perfect. Chief Justice Latham is perfect in Chicory. Followed by, Malas, 1 9 judge and 1 7 judge in India. Shirur Math and Jindal. Now in this, Malas, dead rent, first of all, the points are the same, Malas. 3 elements: compulsory, non-voluntary, exaction, and Malas, enforceability. Same. Here the additional point is, it is not based on what you extract.
Nature of a tax.
As a matter of fact, the better way of looking at dead rent is it's a charge on you taxation for squatting or for, Malas, idling. You just idle. Either, Malas, my learned friend Tushar Mehta gave a reverse example. I would think the better example is that you sit and do nothing. He gave an example that you overexploit early. Suppose you do nothing. You are depriving this man from getting it. You are not contributing to the country and you're sitting idling. So dead rent comes in, irrespective of whether you extract or not. Now, Malas, in this, B31, Malas,